As we say in big civil firms, let's go back on the record. So you have now you've got the hearing set down for the motion for new trial. How you handle the hearing, in my opinion, is sort of up to what kind of lawyer you are, but also what kind of issue are you raising. If you're going to argue that the jury charge was an erroneous statement of the law, then you probably can just have a hearing where you're making an argument to the court. Okay? But if your argument is that trial counsel was ineffective because he didn't do A, B, and C, I think the case law says, well, no, at the motion for new trial, you've got to have counsel take the stand so that there's a record of what he did and why he did it. Because usually actions of counsel are, for the most part, presumed to be okay, presumed to be strategic. I had a case recently, in that Canty case, one of the sub-issues was one of my best friends tried the case, and during sentencing, the state wanted to seek recidivist punishment because he was a repeat offender. And the district attorney stood up and said, Judge, the maximum sentence for this is 20 years, and since he's a recidivist, you have to give him 20 years, and he has to serve all 20 years. It's not the law. He has to get 20, but the court still has the power to split it up. He could give him 20 years probation if he wanted to. Well, my good friend said, yeah, Judge, I think the recidivist statutes are really confusing, but I think he's right. Well, I had an issue of ineffective. Now, because the record was real clear at trial that that was a mistaken understanding, I didn't have to have that other evidence during the motion for new trial phase. But let's say your defendant says, I gave my lawyer the name of 3 alibi witnesses. They were out in the hallway during trial and he didn't call them. Well, you know, Ricky, you got some explaining to do. And that's how you've got to have a hearing to give the counsel the opportunity. He may say, oh, I just forgot. Well, you've laid the foundation for an ineffective claim, okay? The idea is how you handle the motion for new trial hearing is a decision that you've got to make weeks in advance if you have that much time. And it does require some consideration and careful thought. Because if you just go in there and say, well, he was ineffective because of A, B, and C, if you haven't laid the proper factual basis for that, you might not get very far with appeal. Get a ruling on the motion for new trial. I have some judges who will rule pretty quickly. I've got judges who will sit on it. In the usual situation, Judge Gates-Pede will go, I'll deny your motion. And I think lately he got mad at me because I come to the motion for new trial hearing with a blank order saying motion denied because I expected to deny it. And he always gives me the, you mean you didn't think? I'm like, you kidding me? And he's a really, really smart man. He is a really good judge, but he's not going to grant the motion. And consider this for a minute. What I try to do is I try to bring a written order with me. And I do that because I want to control the timeline. In a recent one, I've got, in fact, this is at the Court of Appeals now and could go to the Supreme Court. We went to the motion for new trial hearing. He announced from the bench it was denied, and we presented him an order expecting him to deny it. Now, why is that important? Well, here's my thinking. Once you file that thing, then the 30 days starts running to get a notice of appeal filed. That's one of those, once that's filed, things start moving a lot faster. The other thing is, I want to make sure I know when the 30 days starts. The last thing I want to know is, oh, the judge denied your motion, and the clerk may have filed the order or not. Or in Bullitt County, the order is in this big pile of stuff to be filed at some point. And you know what matters is when the order's signed, it's when it's stamped in and filed. So what I try to do is bring an order, have him sign it, and then I'll go down there and stamp, file, and file it. So I know when the 30 days runs and when it ends. Yes, ma'am.
If your motion for trial and hearing is based on ineffective assistance of counsel and you've brought in testimony and there have been disputed issues and so forth, would the judge have to issue an order or a decision that goes through that evidence and makes his fact findings?
No. In fact, they probably should, but what we get is having read and considered the motion for new trial, the motion is denied, period. Those are most of the orders that I get on motions for new trial. And that's a very good example of why I want to get an order myself, because if that happens, when you go up on appeal, you need the transcript not just of the trial, but of that extra hearing, okay? If you get an order, or you say, Judge, I'll present the order when I get the transcript, you're able to manipulate the timeline so you've got what you need. Does that make sense?
I understand about the timeline, but as you go on to subsequent habeas and so forth, what's the state of the fact issues on the ineffective assistance of counsel?
Most of my judges don't address that specifically. So what happens from my standpoint is, I address it specifically when I file my appellate brief by saying, the defendant's conviction should be reversed because he was denied effective assistance in sentencing, and here's why. So it's like, in fact, I like the general orders because then when I start going up on appeal, I frame the issues the way I want to. Cindy, did you have a question?
Well, it was kind of more of a suggestion. You may want to, before you do that, find out what type of judge you're in front of. Because I've had situations where when I prepared the written order, one particular judge seemed really taken aback by it. He's like, I want the state to prepare it because they're the winning side. They should be the one. And then I had another situation where a judge, I don't know if y'all know Judge Kathy English from Survivor. I mean, he never grants a motion for new trial, and I had one prepared, and he was like, you had one granting it too, right? And I'm like, yeah, right. But yeah, I mean, it really does, depend on the judge too. I think it is a good idea because I've had situations where they finally issued the order and then we never get a copy of it. And then the 30 days run out. Right. So at least if I have the written copy, I know that, okay, this is the day that I need to follow my next appeal.
That's a good point. That goes back to what Perry Brennan taught me 20 years ago. The number one rule of being a lawyer is know your judge. And that's a good point. You need to get a ruling and it needs to be in writing. Then, once it's in writing, it's denied and it's filed, that 30 days begins to tick. And that's when you're preparing your notice of appeal, as Chris talked about. And he made a good point. You need to determine at that point, what court am I appealing to? Because it has to be stated in the notice of appeal. And this happened to me in the sex offender appeal. Gerard and I were at the Supreme Court the same day when I argued the cruel and unusual punishment aspect of the sex offender statute. And I filed my notice of appeal. And weeks went by, and I heard nothing from the Supreme Court. And I went over to the same clerk I've been talking about. Oh, I said that weeks ago. And I was pulling my hair out. I didn't have much to pull out, but I went over there, and finally, one of my friends who works in the clerk's office, and may well be the only competent person in there, went and pulled the record. She did send it to the Supreme Court at the wrong address, prompting me to say, in Bullitt County, it's easier to win a case at the Supreme Court than get a case at the Supreme Court. But, that's a little thing. You kind of got, those things happen. This is when you have the clerk's offices were moving to other places. She hadn't kept up with it. So now in my notices of appeal, I put in there, this case goes to the Court of Appeals, and I put the address in bold. I mean, that's kind of tacky, but you need to determine which court it goes to. It could go to the Supreme Court, it could go to the Court of Appeals. It depends really on your issues. Then you file your notice of appeal within 30 days of the denial of the motion for new trial. And it's important, this is something, a lesson I kind of had to learn, is the order on the motion for new trial may be signed by the judge, and the clerk may say thank you, but they could have a big stack of stuff to be filed. And until that thing is stamp filed, it's not really filed, okay? So just be careful of that. It's 30 days. The notice of appeal has to be filed within 30 days of the day the judgment is entered, which is stamp filed. Gerard.
Hey, one suggestion or something I do, and this works really well in a county that has electronic, docketing that you can can look up on the internet, like the CAB, I don't know how many other counties have that, is after I have a motion for new trial hearing, I then put on my calendar 30 days, file the notice of appeal. And then I just check, and if there's no order, then I move it down 30 more days. And then I'm just, because there are a lot of judges, or there's some judges in particular I can think of in the CAB that I'll never get the order.
Right.
It'll just get filed and that'll be the end of it. So if I'm not affirmatively checking every 30 days, that way I make sure I don't miss the deadline.
And the flip side of that is, you might have judges who heard your argument on the motion for new trial and haven't issued an order, and maybe they forgot about it. I have a case right now where we had a motion for new trial hearing in Scranton County with Judge P, and he said, well, I want to think about it on this one issue. But he's been thinking for a long time, and I think he just forgot about it. So I sent him an email that said, this is a friendly reminder, I still need an order on that. Okay, thank you. I can't figure out what he's doing, but sometimes you kind of have to prompt them.
So if you have had an evidentiary hearing on ineffective assistance, and don't you want to wait until you get the transcript of that hearing and review that and determine how you're going to present that argument in the appellate court, and then after you've done that, present the judge with an order?
Yeah.
And can you count on the judge not gone ahead and entering an order before you've done that? I guess you ask the judge that you'd like to review the transcript and then subsequent to that present him with an order.
I think that's a good way to do it. The judges I'm in front of, and all judges are different, okay? Some judges are self-starters who will issue their own orders. And mine are kind of like, I'll deny your motion, you want to submit me an order? You know, and so you kind of have to, we're given the opportunity to manipulate that timeline. That's a really good point. You do want that time. You want to be able to get the transcript of that ineffective hearing, but also a chance to digest it. Because it may end up being, well, it didn't work out the way I wanted it to, so, or it might be, wow, this raises a whole new issue I've got to research. What happens when the notice of appeal is filed is the clerk of the trial court has to pull the record together, and the record, as Chris indicated, is the transcript, but also all the stuff in the file, and sends it up to the proper appellate court. Once, you know, and then she produces an index. Go look at the courthouse file. Go look at what she sent, because what she's supposed to have copies of what she sent. One of the cases at the Court of Appeals now is went up there, and this clerk's a good friend of mine, and she sent some stuff up there, but she didn't send the whole record. There were a couple transcripts that weren't there. There were some charges. I was making a jury charge argument. She hadn't sent the charges up. So don't assume all the clerks know what they're doing. So go over there and pull the index of the record and see what all she sent up there to make sure, if you've got an argument, for example, that a charge was erroneous, you want to make sure if you submitted, or the trial counsel submitted a proper written instructions at trial, you want to make sure that goes up there. So the Court of Appeals knows you've preserved the issue for appellate review. Okay.
Yeah, I was just going to suggest something. I know that this happens in some jurisdictions, that, you know, where people have good relationships with the clerk's office, and particularly the people who transmit the records on appeal. And what will happen is that they'll just arrange for that deputy clerk to call them, you know, give them a call when the record is ready. And both sides actually can come over and just give it a look over and make sure it is complete before it goes over. So if you've got, you know, if you're dealing in a place where you know, you can do that.
That's helpful, because you might say, well, you know, he denied my motion to suppress, and I want to make sure the actual motion goes up. You want that included?
Or the request to charge, which, as you say, if frequently admitted. A lot of times they're just simply given to the judge, and they just never make their way to the clerk's file. I was going to say, too, that's a great juncture to get an index to the record as well, because you're going to need that eventually when you write your brief. And the clerk will actually prepare that and send it up with the record. And so if you're going over there to check, you know, grab that.
Well, once that stuff goes from the clerk to the appellate court will send you a notice called the Notice of Docketing that Chris described. The one thing to remember is, at this point, you get the Notice of Docketing. It says you have 20 days, and they must send it with a 2-cent stamp, because every time I get it, I've already lost almost a week. That's why preparing a very detailed First Amendment to the motion for a new trial, this is where it pays off. You get it, oh, I've got 13 days, big deal, I've already written it for the most part, I've just got to rearrange it, okay? There's nothing worse than getting a notice of docketing out there when you haven't done that. And you're pulling your hair out, scrambling to meet that deadline. So if you're ahead of it, it's not that bad. And lastly, at that point, they tell you that here are the deadlines, here's when you submit your brief, and they refer you to the Court of Appeals rules. And I'm not going to get detailed into what the brief should contain, because Chris already has, but I do want to make a couple practical suggestions. There is a great book called Making Your Case, The Art of Persuading Judges by Brian Garner and Antonin Scalia. I don't think I agree with Antonin Scalia on anything, but that is a wonderful book. It's become my Bible. And it splits the book into brief writing for appeal and oral argument. And I studied it. When I went up there to do the sex offender oral argument, I had read that book backwards and forwards. It's got some great, just practical suggestions for what works and what doesn't work. The other thing I would suggest is, when you're doing a brief, you have to consider little details like what font to use for my computer. He discusses some of that. And there is the website of the U.S. Court of Appeals for the 7th Circuit has a link on there, and they have a little discussion about what fonts should be used, what fonts shouldn't be used. It's enormously helpful. All right, that's all.
14 times New Roman.
What'd you say?
14-point times New Roman.
Right. But that kind of stuff matters, and that book is great and get it at Barnes & Noble. And that website site from the 7th Circuit is tremendously helpful. Sure.
I have just another one of those sort of nitpicky timing things. And you're mentioning how long it takes the Court of Appeals to send you mail. This reminded me. A lot of times at the very end of the case, when you're about to turn your case over to your client because you lost, which unfortunately we lose a lot. In the past, it would take, and I'm in DeKalb County, it would sometimes take me 6 days to get to the denial. And then my client has 4 days to get a motion for reconsideration into the Court of Appeals or a notice of intent to seek cert. And then I'm feeling bad that I can't possibly get it to my client in prison in time, and then I find myself doing a pointless, frivolous motion, or notice of intent to seek cert on my client's behalf. And I finally learned Westlaw, and probably Lexis does too, I don't know, but they have this function called alerts. And so what you can do is you can program it to run a search every day. And so I just program it to search for the case number, A10, A2345. And it just runs it every day quietly. But when it gets a hit, it emails me the opinion. So usually, like, I'm taking a shower in the morning, and I'm like, on my BlackBerry, I'm like, oh, I just lost this case. And then so I can send my client something days before I even receive it in the mail.
So, Jordan, let me ask you about that now. You're talking about technology, so I've got to ask questions. You mean you can do a Westlaw alert? For example, if you're waiting on an opinion from the Court of Appeals or Supreme Court, and it becomes maddening when you're getting close to when you expect the opinion because you check the website 7 times a day. But you don't have to do that with the alert. Is that what you're saying?
That's right. It'll run 3 times a day, I think. For some reason, it always finds them in the morning. And it takes, you don't get it the same day. Westlaw doesn't get the opinion out until sometimes 2 days later, but usually 1 day later. And the Supreme Court, of course, they always come out Monday, and you can just check. But the Court of Appeals, the only way you find out is if it's in the mail or if it's on Westlaw. So I find that to be highly useful, because then I can just very quickly get that out to my client and let them take it from there, just assuming I'm throwing in a towel at that point.
Okay, I'm going to sit down. Ask Mr. Stubbs to come up while I get some more water.
I'm Tom Stubbs. Y'all are, a good bit of you, some of you seem to be too young to remember the Bullwinkle Show. They had a sub-cartoon within the Bullwinkle Show called Peabody. I think it was called Peabody. Mr. Peabody was in it anyway. And at the end of that, it showed a parade and some guy just sweeping up down the. Well, I feel like that you've gotten pretty much what you need, and I'm going to just touch on a few small things, and then say something I shouldn't say at the end. Tradition I have.
Only one?
Yeah, down to one. I'll start right there with that. I take that Westlaw alert to one other level. I have every morning appearing in my email box every new case issued by the Court of Appeals, the 11th Circuit, the Georgia Court of Appeals, and the Georgia Supreme Court. You want to become a great lawyer, don't follow my practice except for this one, and do that, because every morning you glance down these cases and you will see law issued and you'll catch all the new cases. One of the neat things is exactly what Gerald said. Folks don't get their own cases usually until way down the road. I can't tell you the number of people I've told the outcome of their case and they said, what? It's great. You can email your friends, you see a case came up. The only problem is the early edition is hard to see the name of the lawyer actually on the case. When Westlaw first gets it, that's not included in the initial publication of the opinion. On their site, you have to take the case number, go back to the court, put in the case number, and you'll see who the attorneys are. But it's a great way to track issues. It's a great way to keep up with the law in general. And that will go to my second appeal, general appeal. Give up the big firm law. I'm serious. I don't know how many of you went to school for what you're doing right now. If so, I don't mean in this room, but in your big firm. Congratulations, you found a great place to make a fortune and do some stuff. But I didn't. I wanted to make constitutional arguments. I went to law school because of the very things that I was not doing as an economist. I was an economist in a prior life. I had a graduate degree in economics and worked in the U.S. Senate. I came to law because of the rights of people that are beyond economics. In the back, we've heard, if you haven't been introduced to Jim Bono. Jim is a participant in any number of legal forums. People write on emails on the listserv for criminal defense lawyers questions, and usually within 3 seconds there is a response back from Jim. You'll notice Jim has one arm. And I wrote him one time and I said, son of a bitch, how did you write that fast one arm? And he said, I make it up and nobody ever checks me. The fact is, he is part of the second part of what I'm going to talk about, and that is resources to help you in your appellate work. First, if you can swing it, just for the time that you're going to be doing this, and just because it's a phenomenal organization that warrants the support of everybody, I'm going to urge you to join the Georgia Association of Criminal Defense Lawyers, GACDL, G-A-C-D-L. When you do that, you'll also be eligible to join the listserv and see the daily musings, rantings, and amazing insights of attorneys across this state. And by the way, my father grew up in Scriven County. It is the teenage pregnancy capital of Georgia. There's not a whole lot to do there.
I have 5 kids, but I grew up in Savannah.
Big city. But you will get things like this. This is What's the Decision publication they put out. But for me, really, that listserv is every day's CLE. It's like drinking water from a fire hose sometimes, but you'll find it to be a great resource and a place for you to go when you have questions, basic or advanced, about a judge, about a situation. You can get great help on everything. And about a third of the time, the answer will come from Jim Bono. There are other organizations. The National Association of Criminal Defense Lawyers is also an excellent organization. You can get some beautiful, glossy publications from them. And if you've got a lot of money and you want to join something, you can get that. They have a publication called The Champion, which makes for a very good reading. This stuff is actually inspiring for me. The American Bar Association, which I bet a lot of you are members of if you're in a big firm, they have a criminal justice, I call it their token criminal justice division, because they want to look like there's all things to all lawyers, but they're not. But they do have that, and they do have good articles in there. Second, they actually have fascinating articles. The appellate work. You've seen Chris McFadden. If you didn't know about his book, I saw a lot of you raise your hand. When you've done appellate work, you're going to want to consult his book. It's not just his book. There are others in it, but it's his book. There is another book, does take at some distance to suggest. This is the old edition of the book put together by King and Spalding lawyers, Chilton Varner and Sam Griffin. There's a chapter in there on preparing the record that I prepared, so you want to steer clear of that. But otherwise, it's a pretty good book, too. Now let's take up just a few details in what was said before. Another reason for you to prepare the order yourself. I'm going to take a little bit of issue that the file date is what you have to pay attention to. He was talking about the file stamp date. That is normally the critical date. The judges can enter an order non-pro-tunc. Non-pro-tunc means it's got a retroactive date. And if you've got a son of a bitch judge who's pissed off and there's been a delay for some reason in the order being entered, he may enter it non-pro-tunc back a week or 2 weeks ago. And your time for appeal, your time for motions is measured by the effective date, which would be that earlier date, not the date that is filed, not the date that is signed, but if he's put a non-pro-tunc portion in the order, that's the date by which you have to watch to measure your calendar. So by preparing the order yourself, and that's the case of Ross versus State, 2003. I may have missed it. It's been overruled.
I think so. I sure hope so. I'm pretty sure it has.
It should be.
It greatly needed to be overruled, and I'm pretty sure it has been overruled. But the mistake might reappear. So as a cautionary thing, I would concur with the suggestion to try and get it in that date. But theoretically, if that's the law, a judge can reduce your appeal time to less than 0.
Has Ross versus State been overruled on that issue?
I think it has.
All right. Thank you. Never mind.
I think it was, it finally got to a case where a guy had been screwed out of his right to appeal by the order. And it was really one of those things that, it was a mistake the Court of Appeals had made. It was just awful.
Horrible ruling. Horrible ruling.
Yeah.
I'm glad they got it.
Well, I think I think the restriction is that it can't be used to deprive you of a right to appeal.
Good, because that's exactly what it does. That's kind of, in the civil context, that's sort of a Judge Andrews argument. He's ruled that you may lose your right to appeal an injury that you didn't know in the medical context when this comes up often. You didn't know you had it until after the time to file a claim has lapsed. And he's a strong advocate of your SOL, bud. And that kind of thing does find voice in our Court of Appeals judges. One bad. Notice of appeal. You know this if you've done civil appellate work because it's the same thing. You have to be bizarrely redundant. Don't just say, I want to send everything up on appeal. Say it several times. I want to send everything up on appeal. If I've been in any way unclear, I mean to include everything. And if this is read to include to mean that anything may be omitted, that is not to be read that way. I mean to include everything. And then you go to another paragraph on the transcript. If you don't specifically mention the transcript in your notice of appeal and they fail to include it, you may have waived your right to have that in there. You need to say, and this includes specifically the transcript. The Georgia courts are, in some respects, so much friendlier at the Court of Appeals level than the 11th Circuit Court, where they have atomic consequences for things like this. You have a case go up there on briefs. It's not been a hearing at all. And there's a form you have to fill out for transcript requests. Well, you got no transcript. No need to request it, right? Wrong. If you don't file a form saying, I don't need a transcript, they will dismiss your appeal. Not that that's ever happened to me twice. Twice. A good friend of mine who, extraordinary criminal defense lawyer and well-renowned, and I were comparing one day how most of the job of the criminal defense lawyer is groveling. You grovel with the DAs, come on, he's a good guy, come on, let's do this. You grovel with the judge, come on, the sentencing. Groveling to the 11th Circuit is very difficult. They really don't let you in to grovel very easily, so but you can grovel and get back in. Next, we touched on the index, and I'm sure those of you who've been involved in appellate work know about this, but let's just make sure to cover it carefully. When you get the record going up on appeal, you have to refer to it in a certain way. And you need to, I usually end up going over to the Court of Appeals, getting a copy of, or having them send it to me, this index. They put things in according to boxes or according to certain binders. And you refer to parts of the record by virtue of where it is. So it'll be in Volume 1, Part 2, and they're all paginated consecutively. So it's not enough to know just the transcript. They may have a special way to refer to the transcript, although they usually are referred to distinctly as a transcript. You can usually work on the pagination of the transcript. But the rest of the record, you're going to need to go visit and see that index. And to tell you the truth, I usually share that with opposing counsel. I go in there, I make notes on their transcript of where each entry begins on the page, and I send that over. And I do that for two reasons. One is it's a not decent thing to do. The other is they can check and they call me back if I've been nice to them. They'll say, by the way, you got a page wrong here. So do that kind of thing. You find something's missing. What do? The place to correct the record is in the trial court. And I swear I have this frequently happen. Sealed transcripts seem to be a real puzzler for court clerks. Well, it was sealed, so they must not have ever looked at it. It can't be part of the record. Jesus. You file a motion, usually after you call opposing counsel. You see if you can work it out to have the record supplemented to include any evidence or transcript or other thing that is omitted. Every once in a while there'll be a correction needed. I have had transcription taken down that's absolutely flat wrong. And the other side agrees. And we will stipulate to the record being corrected that way. But there's a procedure under the appellate court rules where you go to the trial court to have that done. 9 out of 10 times I've had the cooperation of opposing counsel on that. And you especially want to look for if there's been some sort of motion on to suppress, granted, and evidence not allowed in, that somehow may not have worked its way into the record, which needed to be in there. It was offered in connection with the motion. You want to watch that to make sure it did not get omitted by accident because somebody just didn't pull it in because well, it didn't get in. That's part of the record. It didn't go to the jury, but it is part of the record. The last thing, and we're going to have plenty of time for questions, but I'm going to go off the reservation a little bit. I'm going to ask you to do something. You're about to engage in an amazing thing, I think. Criminal work is the most interesting work I ever have done. Appellate work is some of the most important criminal work you can do. We shouldn't be here today. This is a failure of our legislature to have any decent leadership. You're about to encounter, and I don't have any doubt, provide the most able, outstanding assistance to these folks we could have. But the fact that we are in a room getting people to volunteer speaks to a funding failure in the court, in the legislature, when the funds have been up. As you work, I hope you develop a sensitivity to the importance of your work and that you consider how important it would be for having people within the system as it was designed to carry out that work so it's funded fully and not by virtue of the good grace of amazing people like you. That's your choice. But this is a vital issue where, as the Pakistani lawyers showed when they stood up and marched, streets when that Supreme Court was set down. But there's been a failure of our leadership. You will be positioned better than anyone else to know how much we need your work, how much that vital importance is, and how much it's an obligation of the state to provide. I hope you take some time to consider those issues, and whichever way you come down. And God knows there's no right or wrong in making our system work. There are a lot of different ways to skin the cat. But don't do your work and walk away. You're touching on something that is a very important part of our system. The very first vote I took as a member of the Board of Governors was to recommend implementation of what is now the statewide indigent defense system. It's the proudest vote I took. We set up a mechanism to fully fund it, and those funds have not been provided. Those funds were diverted. Talk to your political leaders. The leadership and the council is hamstrung, and of course I've got to work with those folks in a way that you don't. So you're in a position to be much more free with your thoughts than they are. So I'm off the reservation. That's not authorized. That's not representative of anybody here. I'm bad for saying that, but it's what I believe more than anything that we need to do as the next step. And that is provide this as an ongoing basis. I think we now have a facilitator for questions.
Anybody have any questions about some of the things that we've talked about? Is everybody awake?
Robert, I just had a comment taking off on something that Tom said, you know, about dealing with opposite counsel. Actually, appellate litigation is a wonderful opportunity to exercise professionalism. I realized this fairly recently when, I don't know, I was in a position of having to ask the Court of Appeals for an extension, and I knew the other side, and it was going to put the other side in the middle of a holiday, and I knew they were going to ask for an extension. And that brought the realization to me that, you know, in large measure, we two lawyers were on the same side, and that, you know, our opponent mutually was the Court of Appeals and what it was going to do to us. But what Tom said about furnishing the index, talking about stipulations, both sides are going to, you know, have problems like that where something was intended to get into the record for some reason or another didn't get into it. And I think doing appellate law is kind of like playing chess. There are not really any concealed moves as there might be in a trial context where you do play games of ambush and that sort of thing and seek that kind of immediate advantage. But on appeal, everything's there in the record, you know, that you can't, if it's not there, it didn't happen. It's just like in a chess game, everything's out in the open, no moves are concealed. The motives may be where you're going, maybe you can conceal, but you know, there are a lot of advantages with operating with your opponent on a friendly basis at that particular level, and find your back scratched as often as you're scratching the office.
And you know, the other thing about this is, a long time ago when I clerked for Supreme Court Judge in Savannah, a guy who has influenced me considerably in my life as a lawyer, but he talked about criminal defense lawyers in Savannah, and he was explaining the difference between, you know, having a motion hearing on summary judgment and reading those briefs, and like a motion to suppress with the DA and a defense lawyer. At least in Savannah, he said, you know, the criminal defense lawyers and the DA, they just don't do a lot of good written work. This is a good opportunity for all of you, who I'm sure are good writers, to put that into a much needed area, which is putting together very well written appellate briefs, even though they deal with, you know, criminal issues. I remember that was a need, and even in my circuit, a lot of the lawyers who are not in my office, who do a lot of criminal work, don't do or like to write. And, you know, and in my opinion, to be an effective lawyer, it's not just giving a great closing argument or doing great oral argument in appellate court, but writing is also really important. So this is a good opportunity to hone those skills and provide them in a much needed arena. Any other comments or questions? Yes, sir.
Would you give us a sense of what to expect our relationship with trial counsel to be like? As we're going through this, what can we expect trial counsel to help with, push back?
Excellent question. Hey, you guys want to start?
It'll vary. I mean, I'm sorry, it varies. For the most part, they get it in my experience. They understand that a critical avenue of defense for their client will be ineffective assistance of counsel, and they will acknowledge where they had done things incorrectly as opposed to not have been strategic, but it varies. You'll find some folks who see a malpractice claim coming, and they get real, no way, it won't help you at all. So I wish I could say, but it just varies. Attracting more flies with honey than vinegar, so you just start out being nice and say, come on, help me. See if we make it a cooperative venture.
Chris? I have nothing to add to what Tom said. It's entirely consistent with the range of my experience.
I've had, I sort of became the, we were talking about this earlier, I became the appellate division of my office because trial counsel hated appeals. They try cases, they lose, They file a motion for the skeletal motion for new trial, then they bring me the file and say, here, I hate appeals. So I started doing all the appeals in my office. So you'll get guys who are like, oh, thank God, I don't have to do the appeal. Or you'll get guys who will say, are you going to allege ineffective? And, you know, most professional lawyers will say, let me explain to you what I did, we can talk about it. But some of them get really defensive. So that's exactly right in the barrier. Yes, sir.
So what are steps you can take if you can't get they're uncooperative and you can't get their trial record?
I think that's a tough question. If they're just not cooperating, first of all, I think that I might be wrong on this, but let's say they're saying, I'm not going to talk to you and I'm not going to provide you my file. I think the file belongs to the client. And, you know,
The State Bar will help you extract it from them.
But you know, what's tough about that is, let's say that you think there's a legitimate ineffective assistance claim. And so you've got to have their live person at this hearing we've been talking about. You know, and if they won't talk to you ahead of time, it can be tough, because the only way you get them there is to file a subpoena. And the first time you get to talk about the case is with that lawyer on the stand. I know one lawyer, Michael Edwards, is the chief public defender in Chatham County, which is in Savannah. And he and I were talking about some of these issues last week, and he said there's one particular lawyer. When you deal with her, she is hostile, she will not talk to you, and if you subpoena put her on the stand, she will try everything she can do to still be hostile on the stand and gut your claim. Some lawyers are very proprietary, I guess, about that stuff. That's a tough situation, and you know, you're kind of stuck having to use subpoena powers to deal with it.
Conversely, I've got a case where I've got to winnow all the ineffective assistance claims trial counsel has suggested to me.
Gerard?
Bringing up subpoenas, I can't tell you the number of times lawyers in my office have had ineffective raised against them by outside counsel. And they're like, I've never been subpoenaed. I think, generally we think, hey, we can trust the lawyer to show up, but basically all I do every day is raise ineffective on other lawyers. And the last thing I want to do is be ineffective myself. I subpoena every trial counsel, no matter how friendly they are with me. Because, I mean, you just never know, and if something comes up, you need that to get continuance. So I subpoena the friendly ones, the unfriendly ones, I subpoena them all.
I have an assistant in my office who is much older than I and had a lot more experience than I. And you said ineffective assistance to him or about his performance, he would throw things. I mean, you can see the red going up his face, and it's not a personal attack. I mean, it's a constitutional professional observation. But he would get just crazy about that. Yes, sir.
Yeah, I have to comment that this discussion really is, I can see how it could be a bit discouraging given the context of this program, trying to get associates in big Atlanta firms to take on these cases. Because what you're looking at is a second or third year associate in one of these big fancy Atlanta law firms going down to Bullitt County and accusing some boy who's been practicing law in Bullitt County for 30 years of being ineffective. How do we deal with that? How do we deal with that practical problem if we buy into this program that the Standards Council is asking us to buy into?
That's a really good question. Jiminy, do you have an opportunity?
Because that is my testimony, that is my song. Whenever I go out, and I was introduced to Jiminy Rogers, director of the Health Division, we go out all across the state, and we go down to different areas, and when they see you coming, known as the carpetbagger, and there's a lot of places in Georgia where it's obvious that I'm not from around there, and they know I'm coming, likely to raise ineffective assistance of counsel, and so part of that is you start out, you want to call the judge, you want to call the DA, say I'm coming down, you make friends over the phone, you play nice up front, and then you still have to deal with the issue of the trial counsel who may say, at least I'm in the public defender system, who may say, you know, what are you doing down here raising this? And you do get that pushback sometimes. But you really just have to do it. Sometimes you won't get it. You're graciously welcome. You may not be welcome on that point. I've had a trial counsel tell me, I'll say, you know, whatever I need to say on the stand, but if you come after me aggressively, I'll growl at you when I walk away. And that's fine with me, but that goes to the temperament of the trial counsel. So you just have to kind of make friends before you go, but realize that, you know, depending on the temperament of the trial counsel involved and the judge who probably likes that trial counsel and doesn't like the fact that you're coming to raise ineffective assistance of counsel with them, that, you know, you just act professional and then you move on, you get what you need.
I think that's a good observation. I was challenged in a vehicular homicide that I tried, and lawyers from the Brunswick area, which is down in South Georgia, and he got a conflict appeal from the Standards Council, and he called me up, was very pleasant, said, look, I want to look at this, you know, I might have to allege this, and I said, fine. You know, I think the fact that he made a phone call and just talked to me about it made all the difference in the world to me. And you're right, at least down our way, you know, they all fear Atlanta lawyers. And of course, an Atlanta lawyer is defined as any lawyer who practices north of Macon. That's the way it's viewed. And the way, what I would suggest is, make contact with the lawyer if you are going to make an effective claim. You can sometimes gauge the temperament of that lawyer and how they're going to respond to it. Assume for the sake of argument that that lawyer is hostile to you. I'd make a call to the circuit public defender, because we support everything that y'all are doing and are glad you're doing it. And like in my circuit, for example, I think for the most part, if I had a defense lawyer who was upset about that I could say, look, you know, give the guy a break. He's got a job to do, and it's a tough job. And I think for the most part, they'd cooperate. So I'd say, try to be professional with the lawyer and the district attorney, and then make a call to CPD if you think there's a problem. And usually, most CPDs will try to smooth the way for you.
Obviously, goes without saying, when you call them up, you don't say, I just screwed up. You call them up, you say, can you talk, what do you think would be some decent avenues of appeal? When you call, be sensitive to just what they just perfectly described, what you were coming across as. And if you're coming in solicitous of their thoughts, they may come to that for you. You don't need, you know, you don't have to have the fight. Say, you know, at the end of the day, you know, after all these, here's some places where you may have ineffective assistance. But start out with, what angles do you think we have on the appeal of this case? And working from there, build a relationship, build a conversation with them on that issues, and then having built that, if you need to, move over to the ineffective assistance issues.
And, you know, that's not just a matter of tactics in relating to the trial counsel. I mean, one of the most useful ways you can spend 15 minutes starting out and working on an appeal is ask the trial lawyer what they think.
Jim, did you want to get on this?
Just briefly, the Bullitt County or the South Georgia scenario is part of what we do is we have a statewide system. But I would say that the bulk of the cases that come to us, as you might expect, the bulk of the trials are really in Atlanta, in the Atlanta area. There are other pockets where there are trials of cases, Augusta, or your larger mid-major metropolitan areas in the state. Rural areas have some, but the bulk of this work will likely be from the metropolitan Atlanta area. That doesn't mean that counsel is going to be nicer to you, but maybe there won't be quite the judgment of Atlanta lawyer being north of the gnat line, as we say. But that doesn't mean there won't be cases in other parts of the state. And a lot of the cases are actually public defender handled. I mean, most of them are going to be handled by the circuit public defender offices. And you met Robert; he's a perfectly reasonable guy, and there'll be other circuit public defenders throughout the state who are. And dedicated criminal defense lawyers, professional criminal defense lawyers, very often are the ones that are most likely to talk to you about their cases. There'll be some of these cases would be tried by private attorneys, and you'll have varying ranges of attitudes about, or from the folks that tried the cases. But I don't want you to be overly discouraged by the thought that you're going to get necessarily negative feedback, and that a lot of these cases are going to be in unfamiliar parts of the state. So just as judgment on that.
Yes, ma'am.
I'm getting the sense that the issue of ineffective assistance of counsel is something that gets raised in the vast majority of cases. Is that right?
I think it is. I had one assistant DA tell me one day, he says, all I deal with on motion for new trials and appeals these days is ineffective.
Well, I know how I would feel if someone claimed that I was ineffective or that I had screwed up. You know, I would really, really be hostile to that. Is there a different culture in the criminal defense bar that you kind of go wink, wink? Or are you a bunch of incompetents or what? I'm just stunned.
I'm not answering that, Jim.
I mean, it just, is it something we've just agreed that we'll get to raise it?
I can address your question. Having practiced criminal defense for 18 years, I sort of divided into categories. The vast majority of us are in the category I call true believers, which is we practice client-centered criminal defense. And at the end of the day, our practice is about a human being who may be spending a long time in prison because of what's happened. And it might be because somebody made a mistake. And we all are human. We all make mistakes. And we try to instill in our lawyers in the public defender's office in the Atlanta Judicial Circuit the idea that, you know, if you make a mistake, it's okay. The important thing is to own up to it, because at the end of the day, it's the client who's going to be suffering the result of that mistake. And so I can say almost without exception, the lawyers in our office, they're encountered, it's sort of part of the job, it's part of the culprit. If you are encountered with a claim of ineffective assistance of counsel, go into court, you documented your file, you explain what you did. You don't get defensive about it. And it's just a completely different mindset. And I think the vast majority of that stems from the fact that perhaps in civil practice, if you mess up bad, there's a financial penalty to be paid. Okay? In criminal practice, if you mess up, even if you're ineffective, there's only a couple of situations where that can result in a malpractice claim that's going to have a financial judgment attached to it.
It doesn't affect your malpractice rates?
No, we're covered by the county.
That just blows me away.
Criminal malpractice rates are like the lowest I think you can get, because nobody gets sued.
I think a professional who's, and I've certainly been on the receiving end of claims of ineffective assistance, and I think a professional attorney handles themselves professionally, and they understand that the appellate attorney coming in is doing their job and reviewing their work. And trials happen in the heat of battle, and I think any professional attorney is and should be willing to comport themselves professionally when they're accused of ineffective assistance and be honest about it.
Cindy?
I was just going to add that really, I mean, a lot of these cases aren't being handled by public, or were handled by public defenders. So the way I kind of approach it is, I mean, they have crushing caseloads. I mean, we're talking about a set amount of time for each case that they have to prepare for. So then it goes to the amount of preparation and then whatever oversight that they may have made. And it doesn't go towards any incompetence. It's just, you know, they just didn't, you know, either consider this or just overlooked it. And so that's how I approach it when I'm raising ineffective. But what I was also going to say is, a lot of times you're not going to have the trial court grant your motion for new trial based on being ineffective. So you're really just establishing a record. And so if you just kind of keep that in mind, I had a Fulton County judge actually on the bench start saying that, I can't believe you're letting ineffective. This is the best trial lawyer I've ever encountered. She's won many cases, blah, blah, blah. And I'm like, okay, well, I'm trying to say that she was ineffective in this case, and I'm trying to establish a record so that, you know, the Court of Appeals to the Supreme Court will get to see the record and see what the error, what error was made, and whether it was harmful enough to rise to the level of ineffectiveness of counsel.
Gerard?
Hey, my name's Gerard, and I have been found ineffective by...
Gerard has established the law in a lot of areas.
I've been found ineffective by the DeKalb County Superior Court. I have been found ineffective by the Supreme Court of Georgia. It is, I think most lawyers know that the best lawyer in the world can be ineffective, and especially I think if you do trial work, I mean, you just got to know you're going to be ineffective. I mean, you just can't keep up and be on the game, you know, the entire time. You're going to make a mistake. Everybody makes a mistake. And the best lawyers in the world can make mistakes, and you'll find case law that says that, which you know, you need to use when you run into what Cindy ran into. But most criminal defense lawyers, I think the tone of this, we've been talking a lot about difficult lawyers. I've had a couple difficult lawyers. I've had 2 lawyers that refused to respond to subpoenas. And eventually, you know, the hearing gets reset, and the judge orders them to get their butt in court. But for the vast majority, aren't going to fight you tooth and nail. They may not say good things on the stand, but the vast majority of lawyers, of criminal defense lawyers, understand that, you know, it's a difficult process. There are a million objections you can miss, and that they might have missed them.
How many cases do you try here as a public defender? Approximately.
Surprisingly fewer than I would have thought. I mean, it's been a long time since I've done trials, but it was just, I think the most I ever tried was maybe 6 a year.
My husband's on trial, either in court with cases that are supposed to be ready for trial 2 weeks out of a month, easily. I mean, trying to get a case possible. So you're constantly ready for trial on any number of dozens of cases, many of which are pretty serious murders, armed robberies, rapes. You're constantly being called in by the judge who wants to move their caseload. And so you've got to be ready on many, many cases every week.
So my thought was, to Judy's point, I mean, us in the private bar, we don't try that many cases in a year, and it may be the crutch of caseload that sort of keeps you in that pool, in effect, you know, having some ineffective moments.
Yeah, but also it's just a matter of reality. Everything's not going to be perfect.
Right.
And I guess maybe when I see how ineffective counsel is defined and what would win a case and what wouldn't win a case, I might feel better. But otherwise, my heart goes out to criminal defense lawyers. I feel like we're letting them be slaughtered here. And now we're going to be part of the slaughtering process.
Jim?
I guess one way I can think of it is it's almost an indictment of the indigent criminal defense system that if we gave adequate funding for this, there wouldn't be these crushing caseloads. But it hurts me as a lawyer to go pointing fingers at other lawyers and say they're ineffective when it's just part of the process of trying a case that you can't be perfect.
Well, think about every civil case where you have read in the Court of Appeals decision that the appellant waived that issue because they didn't do something. That happens actually in a lot of civil cases. That result in malpractice usually. But in the context of the criminal case, you've got an ineffective assistance often associated with that. So it's not so unusual even in the civil context. And Gerard or Jim want to begin?
Let Gerard first. Oh, okay. Well, I was just going to say, in Gerard's defense, having confessed to being held ineffective, Gerard is the last person to reverse the Georgia Supreme Court and the Supreme Court. So it's not, he's gotten even. He did the Presley case recently that came out of DeKalb. But what I was going to say, Judy, we're many minutes from your original question, and you asked about what is it a culture thing or something like that. I am renowned for my soapbox that I erect on this damnable Garland case, which is the reason that most of these conflicts have gotten here. And essentially, Gerard wrote an amicus for the winning side of Garland. but the Garland case essentially basically said that if anybody can, the magic words, ineffective assistance of counsel, boom, there's a conflict, regardless of whether there actually is such a claim or not, a viable claim, and the case gets conflicted out. And obviously, when you've got a case, when you've got substitution of counsel on that basis, then you've got a client who has certain expectations. You know, for one thing, he may think he has an ineffective assistance of counsel claim, when in fact all he knows is that he lost the case. I mean, that's which doesn't make the claim. So this is something that this is such a prominent issue in criminal practice. I think is really the fault of the Georgia Supreme Court and their desire to front-load ineffective assistance of counsel claims and not defer them to a separate kind of proceeding that is more amenable to that kind of claim, which is habeas corpus. And we don't do that in Georgia because there's no right to counsel. There are a lot of good reasons for not deferring it. But the consequences of actually imposing that issue, which is in a large sense a change of subject, into the criminal appellate process, it's extremely disruptive. And that's really why you all gathered here. You know, it is so disruptive because we've got, it's essentially requiring the erection of a parallel public defender system whose only putative function is to look over the shoulder of the poor people in the trenches. You know, and most of the time who have not performed ineffectively. You know, and we're going to have a whole section on this later. I don't want to get too far ahead of it, but the problem is that we just have that claim raised promiscuously, and that it just creates certain problems for us in the field who are stuck with having to do it. One of the great problems being to raise it when it isn't there.
Jimmy,